Ripple versus SEC new briefing deadlines set the stage for next legal showdown, with the notification of revised deadlines for remedies briefing. A legal tug-of-war between Ripple and the SEC has entered a critical phase. This marks a significant development in their continuous fight with one another. Attorney James K. Phelan offered some fascinating insights into the revised schedule, noting that the opening brief for the Securities and Exchange Commission SEC is now due on March 22. This will be followed by the opposing brief for Ripple on April 22 and the reply brief for the SEC on May 6, as both parties work their way through several deadline extensions. This amended calendar highlights the complexity and intensity of the legal processes that are now taking place. Extending the Ripple Vs, the set like what happened next. The prior request that Ripple made for an extension of remedies-related discovery was granted in February. The request for this extension was made to accommodate the time that is required to evaluate documents that were recently provided and to complete the briefing that is connected to remedies. In addition, the application for an extension of time that was submitted by the Securities and Exchange Commission was granted at the beginning of March. This indicates that the legal processes will continue, with both parties working hard to fulfill their respective commitments within the constraints of the court's timetable. Experts involved in legal analysis, the Securities and Exchange Commission has a poor understanding of investment contracts about crypto assets, according to attorney Bill Morgan. John Denton further emphasized that the Securities and Exchange Commission is unable to argue the non-security status of XRP, which was determined by Judge Torres, the SEC, about fines for sales of XRP to institutional investors after a complaint has been filed by Section 5 of the United States Securities Act. In the past 24 hours, the trading volume of XRP has decreased by 40%, and the price of XRP has experienced a minor reduction, decreasing by more than 2% to 6 cents. As a result of this, market players continue to have a positive outlook as they anticipate a possible increase in price to $2 this year, contingent upon the final judgment of the current litigation brought by the SEC. For example, traders have opened calls for 9 cents, which reflects their prediction for future price moves in the context of recent XRP rallies. The data from Bearbit Options reveals that confidence is building in the market. In general, is eagerly awaiting the final judgment that Judge Torres will render. At the same time, counsel for the SEC has written to the court declaring that they do not intend to challenge the status of XRP. By the time the deadline for remedies related briefs arrives on March 22, the inflection point for the direction of the XRP price and the bullishness of the cryptocurrency market as a whole will have been established. Lawsuit between Ripple and the SEC might be over soon. Legal challenges brought by the Securities and Exchange Commission SEC against Ripple Labs have been unsuccessful. Judges have ultimately ruled in favor of Ripple attorneys on a variety of points, including the case in which the SEC withdrew charges against Ripple executives Brad Garlinghouse and Chris Larson. In addition, Empower Oversight is exerting pressure on the Securities and Exchange Commission SEC and the Office of Inspector General OI to complete their investigation into the SEC's bias against cryptocurrency and Ripple, with former SEC Director William Hyman being the focus of attention. The conclusion of the inquiry by the Office of the Inspector General will be a deciding factor in the dispute between the SEC and Ripple Labs. Interestingly, the United States Securities and Exchange Commission did not provide any extra authority in the XRP litigation in order to establish that secondary market transactions are securities, because according to the Howey test, they are considered investment contracts. As soon as the lawsuits against Binance and Coinbase were filed, the SEC swiftly submitted a default judgment by the court, indicative of the SEC's continued arbitrary and capricious behavior. The move was met with opposition from members of the cryptocurrency community as well as legal professionals. You may also be interested in reading. BlackRock and Fidelity Bitcoin exchange-traded funds saw inflows of $870 million new dates for the XRP lawsuit following an order by Judge Torres that granted the Securities and Exchange Commission an additional week to prepare for the opening brief about remedies. The revised deadlines for the SEC and Ripple are as follows. The opening brief on remedies-related discovery papers was released by the SEC on March 22. As of the 22nd of April, Ripple has until the deadline to submit its opposition to the brief. The SEC has until May 6 to submit its response to Ripple, which is the deadline. According to attorney Bill Morgan, the Securities and Exchange Commission's interpretation of investment contracts about crypto assets is lacking. Furthermore, John Denton, which is indicative of a fallen interest among traders. In the meanwhile, market participants are optimistic that the price of XRP might reach $2 this year. The final judgment has the potential to set off a tremendous rise, given the price of XRP has not seen much of an increase as a result of the SEC litigation. Because the price of XRP has risen above 7 cents this week, the statistics from Deribit Options indicate that traders are opening calls for 9 cents. An option trading platform for XRP was just recently introduced on the cryptocurrency derivatives exchange.